All right, good evening, everyone. Welcome to another edition of our Justice and Pieces guest speaker series. Today's guest is a lawyer and has been practicing law, I think, since 1987. So a lot of experience, broad practice covering civil litigation, commercial litigation, international trade litigation. Um, was a professor at Osgood and my professor many years ago. I feel uh, I always like to think I'm still young there, but again, young at heart. But I owe a lot to this man there for a great class all those years ago. And as I was telling him before, helping keeping some of my classmates and I connected. So thank you so much, Chuck, here for joining us. Looking forward to hearing from you. Maybe you can start telling us a little bit more about yourself and your practice and how you got into law.
Well, I was called to the bar in 1987. I've practiced litigation law ever since. I got my first law degree I got a business degree at Queens. Spent 3 years in marketing. Got a business degree or a law degree at U of T. Then I got my master's and my PhD at Osgood, working part time or teaching part time while I was working full time, while I was practicing full time. I taught for 12 years at Osgood, 25 different courses, 10 subject areas. I've taught in Cambodia, Thailand, Vietnam. Our firm I did policy work in Cambodia where I wrote some laws for the Cambodian government on their accession to the WTO agreement. Our firm has run a charity in Cambodia since 2008, where we take the poorest of the poor young women from the provinces of Cambodia and we put them through the leading law school in Phnom Penh. We've had about 100 students in the class, and now we've got some of the poorest of the poor, including indigenous students who are now actually have become lawyers in Cambodia, and so we're very proud of that. And right now, I worked at a huge downtown law firm. I worked at a mid-sized downtown law firm, and I've run my own law firm since 2005. And so I know the business of law quite well.
All right, so let's start with the overseas, because I know my own experience there being teaching overseas. What kind of drew you into that? How did you get into Cambodia and Thailand, and what was that experience like? And maybe tell us a little bit more about what you've been doing out there and how that's been rewarding for you over the years.
Stuff. I was always interested in international, and I was the director of for a couple of years of the International Business Law LLM at Osgood, and I used to start off the class by I was asked to give the opening lecture, and my lecture would be, well, you've all been cheated. You're here for a course in a degree in international business law, and there's no such thing as international business law, which is what I believe. And so when you talk about international, it's kind of a strange thing because we as lawyers belong to the most tribal profession in the world. Take the world, okay, now cut it up into countries. Okay, now take Canada and cut it up into provinces. And I'm entitled to practice law in Ontario and nowhere else. And if I get into an area where the law is of a contract or something is a law outside of Ontario, I don't have any insurance. So I can remember going to the International Business Law or Association at Osgood and thought, my God, all these kids who want to get into international law. If you want to get into international law in Canada, you go to the federal government, or you go into mining, or you go into banking, or you move to London, New York, Washington, the Middle East, that kind of thing. But you're really practicing local law and the interface with the international side. So I have a bittersweet relationship with international trade law. I did my master's and my doctorate in international trade and competition law, and I thought that that would qualify me for being, somebody really special. And I found out I wasn't special at all. I had spent an inordinate amount of years joining the smallest bar in the world. There's what, in Canada, true international business law litigators, what, there's 10, maybe, I don't know, 15. Um, so how did I get into that kind of work? I did those degrees with a person by the name of John Gabriel Castel, Professor Castel, who is a brilliant man, who is who remains, as far as I'm concerned, the leading person in the conflicts of laws. And he was French. He had fought in the French underground. He had done all kinds of different things. He knew every prime minister for 40 years. He worked for Mrs. Roosevelt at one time, worked with her on things. And he had a connection with the south of France, and he had a program that was going on. And when he retired, he put me in charge of it, and that's how I got into France. And when I got my PhD, I went out looking for things to do, and I got connected with a think tank in Saskatoon. It was the Estes Center for Law and Economics and International Trade, and that got me introduced to Cambodia. But I had a background in sort of promoting things and setting things up, and so one of the things I was looking for in Cambodia was to start supporting female students in the provinces. And there's a whole backstory to that, which I won't take you into at this point, but roughly that's how I got going.
And how long do you still go over, or people from the firm still are
Oh
over
yeah,
there
we
at some
do.
point?
Oh no, we're involved all the time. We are. If you want, the best way to do it, if you go on YouTube and you search Clue Canada, you'll come up with a number of videos, and you'll get to know the students and the backgrounds from whence they come. And yeah, we're involved on I wouldn't say a daily basis, but I wake up every day with emails and Facebook posts. But they've changed over the years. Before they were all students, now they're students, graduates, their families, what they're doing, and it's a remarkable progression to see people, achieve things that were totally impossible for them. But I have a theory, and I fundamentally believe this. I also had over 70 interns at my firm from all over the world. I don't care who you are. I don't care what country you're from. I don't care anything about you. But I know one thing: everybody's got the same ability if they get a chance. So it's a quality of opportunity, which is the thing that's most badly needed. And so there's no difference between students. The faces change, the names change, the years change, but there's no difference between a student here or anywhere else.
And so you mentioned they're the interns there from all over the world. What kind of where did that start from? And I know you used to have students. I remember when I was a student that there would be some international students coming over. I don't know if you still do that back later COVID, but how was that experience?
That was started up through John Castel and John came to me in 1999 and said, "Chuck, I want you to take a student." I said, "Okay," because I can't say no to John. Whatever he asks, he's going to get. I used to get up in the middle of the night and think, what am I going to do with a French student in my firm? I mean, how is this ever going to work? So I get up at night, worry about it. And then we got to the point where the French student came over, and I said to myself, okay, Bob, this is a 9 to 5 thing. After that, you're on your own. Don't look at me to do anything for you. And it took about a few days before I had to take my kids to drop them off at camp. So I invited him along, and then I knew what this was. What this was not an opportunity for him. It was an opportunity for me to learn about a whole new culture, a whole new background, And it just opened me up to what this represented, and all of it. So after that, we the next year we took 3. After that, it was 5. Then one student came up to me and said, "Chuck, I don't want to come during the summer. I want to come during the winter." Well, what am I going to do with a French student with the winter when the snow's on it? Oh, okay. And then all of a sudden, we had them coming all year round, and we've had students from Cambodia, uh, Saudi Arabia, Thailand, Poland, all kinds of different countries all over the place. We've had them from. I don't do it anymore. I got the academic bug beaten out of me. And
So I think the audio cut out, and it's probably your headphones there that when you move. There we go.
Okay, well, there we go. We're back on. Okay. So I don't do that anymore. It was basically what happened was, I'm going to put my headphones away and just speak over the computer. The practice of law is changing in Ontario, and the business models are changing in Ontario. Can you hear me, John? Okay. And what happened was that our firm was built on some major customers, major clients. And all of a sudden their work was going in-house. So all of a sudden our work was starting to dry up. And so the last year I taught, I actually quit the year before, and Oscar called me up and they said, "Chuck, you can teach anything you want to teach, anything at all, just not something somebody else is teaching." So I said, "Okay, I want to teach the business of law." And they said, "Well, what's that?" I said, "Well, it is." I started off the first class and I said, "If you guys learn any law in here, it's totally by accident, because this is not about law. This is about the business of law." And our goal was to teach students about the practicalities of running a law firm, financing, marketing, the ways you could be screwed over within a law firm, what a capital clause was. We were trying to put students, give them the experience that they would have 10 years out. And during the midst of that, we lost a major client. So all of a sudden I'm sitting here talking about the, marketing and things like that. And I'm thinking, okay, well, my firm's collapsing down around me. How is this going to work out? And so I really went back to brass tacks, and this was a threat to the existence of the firm. And I'm happy. And so what I did was I really concentrated on the business models, and I really concentrated on the firm. And today our firm is thriving, and we're completely different from what we were. And that's a real testament to our firm, because most firms who get into this situation shrivel and die. They're unable to make that change. And so it was that change that really took me out of academia, and took me out of international, and took me out of doing student programs, because I really had to concentrate on the firm.
So yeah, I mean, it's great that there's a course. I mean, I'm hoping there's still a course there like that in Osgood, but it's something that a lot of the people I bring on are people I went to school with, and one of the things we remark is you learn all this theory, but you don't learn about that practicality if you go out and start your own practice, or even working. The importance of getting clients and retaining clients and things like that. So, what can you share from you mentioned at the beginning you worked at a large firm, you worked at a medium-sized firm, and then since 2005 you had your own firm. What do you, from those experiences, what can you share for students looking to get into the practice about the business of law?
Okay. And we're talking about students who have already gone to law school or in the midst of it?
Yeah, let's say students who are able to go through and start their own practice in a couple of years. They can go through writing their licensing exams and getting clients.
I don't know what to say. And given all of my experience, that's I'm rarely at a loss for words. Everything's
Boy, I'll tell you. My advice would be to, if you can, find somebody to work with for a period of 2 years, at least 2 years. I think after 2 years, you become your most marketable that you'll be. And and so that's the first point I would make. The second point I would make is be creative. If in fact, that course that I was talking about, 85, if you took all the issues that could be put before, it could be taken to a lawyer. About 80, it was a CBA study, Canadian Bar Association study, and they said about 85% of those issues are not being taken to lawyers. And so the question is, can you build a practice head on, like taking into one of the traditional areas of law and competing with everybody else? Or is one way you can do it is to find a way to find an area of law which is underserved and to develop it. The definition for me of an entrepreneur is a person who recognizes value where others don't. And in fact, I have got experience in this because I did it. I had the vice president of a Fortune 500 company come through my door. They are involved in business to business, but small contracts. They've got numerous locations or branches or plants throughout Ontario. They've got customers in the tens of thousands, and their claims were anywhere from $200 to 100,000 or more. Most of them, the vast majority of them, are the smaller claims. So he came in and he said, "Look, we need a program," and the traditional letting each plant get their own lawyer, paying on an hourly basis, just didn't work for them. How do you retain a lawyer for $200? And customers were breaching their contracts and were basically laughing at them because they'd never enforced it because they couldn't, because the economics weren't there. So what I did was I set up a program that lost money for at least 2 years. Found out a way to do it, put it online, claims online. We built our own portal now, and we used analytics. We said, okay, it's collection work, and what we did was we got to the point where we could predict what we were going to recover. We tracked everything. We give semi-annual reports where we drill down on numbers right as far as you can possibly track them. And we set ourselves up basically as a business unit within their organization. And now they want us to help them before COVID, they were trying to figure out a way that they could replicate our model in other parts of Canada and down the Eastern Seaboard. Mostly, and it was, I'm really proud of it because it's now become a very important part of our business. And now it's led to other contracts. And it was all because of that class that I took. Because you just got to look at law differently. You have to, you have to be creative. Now, I can hear your students saying, well, who's going to walk through my door? I don't know. Law is a lot different today than it was when I started in '87. In '87, there were a lot more law firms, and there wasn't the stampede in-house counsel that there is now. And yet now there's more variety in terms of, if you take a look at the jobs that are available through software and the development of it, the application of it, specialists in different areas, e-discovery. You've got companies now that hire all kinds of people and do nothing but e-discovery. And I met one of the people who run that company, who ran it a while ago. I was fascinated by what she'd achieved. You know, so that has been my own experience. It's hard for me to answer that question, John Paul. I'll explain why. Because my background was, when I started my own firm, I had been a lawyer for 18 years, and I had a gift from the gods, and that is that I had a law partner who I'd worked with since 1992. This is our 30th year working together. She was my student. Now I think of myself as hers. And we went through a long trial together. So we were war buddies. And, you know, our partnership agreement is everything is split 50-50. And if we have a dispute, we've got a very evolved dispute settlement mechanism, which involves a coin toss. And, you know, we'd rather cut our arms off than cheat each other. And so I was really fortunate. So we had a bit of a practice established. There was something else that was kind of neat. It was kind of interesting. And that is that when we started, and I think it happens for other people too, I get the feeling is there's a lot of very unhappy lawyers in large firms who, if they went out on their own, they could start up their own firms and do really great and have a tremendous amount of fun. Now, maybe that's my own bias, and other people could say, Chuck, everybody who's in a large firm downtown is absolutely happy. And I'd have to say, okay, well, you know more than I do. But you can hide your candle under a bushel basket, or you can let her burn on your own. And people try to help you. I think when you're doing that, they recognize what you're doing. I think, and I apologize for jumping around. I'm just, if I didn't have any other opportunities, I wanted to start my own law firm, and that's what I wanted to do. I had to do it. First thing I would do is try to find a mentor, somebody who's a more senior lawyer that I could bounce ideas off of. That would be the first thing. And there's a caution I would have. There are sharks out there waiting on you. And if you're a lawyer who's in desperate need of a client, you could have a client come along and try to use your trust account for all kinds of nefarious daring do and get you into so much trouble with the law society, your head would spin. So you've got to be really careful. And there's no client that if they come to you and they want you to do something funny, they may be your corner client. Get rid of them.
Now, in terms of, I mean, you mentioned like the people at large law firms that, I don't know, whatever is holding them back from making that leap to go out on their own, and they would be much happier. They'd have their, you know, their candle would burn bright. Is there anything that you learned over COVID, especially? And I know you'd started doing this transition before COVID. Are we past the days now with Zoom and everything that do you even need like put up a shingle downtown anymore, or what's your experience with that been?
Well, let's talk about what are the barriers to starting your own law firm. One of the barriers used to be that it was the fear of administration. Right now, all you do is you practice law. Yeah, you know, you do your thing, you go to your partners meetings, but all you're really doing is practicing law. When you're like I am, you are running your own business. You're running your own small business in every aspect of it. And the worst part of it is human relations. You know, if you have to fire somebody, or if you have to give them bad news, or you can't give them a raise or whatever, that's the toughest part of running your own law firm. So it's administration, which was the thing that was the issue that most people would keep. That would keep them away from it. Another thing that would keep them away from it is, do they really have a practice? Because and this goes to the nature of, and again, this is just my view. I could be wrong, okay? But it used to be when in 87, when I started, and before that, whenever you were hired by a law firm, the whole idea was that you would stay there and become a partner. And if you didn't, then there was something wrong. You didn't see the movement from law firm to law firm that you do now. And so what you had was, and so today, what are your chances of being a partner at one of the large downtown law firms? I think they're much smaller than what they were back in the 80s. And the reason for that is because they hire more students, they hire more junior lawyers. And the whole idea is that there will be attrition in the ranks. Not only that, another thing that happens is that you've got the most precious thing in the world for a lawyer is a client. And so people jealously guard their clients, and they won't necessarily let you or someone else close to them. And they can only bill so much on a file. So if you've got a low billable rate, then fine, you're on the file. But once you get older, longer in the tooth, and your billable rate gets up there, all of a sudden you're kind of draining away some of the resources that can go on those files. And so you might become an orphan within the firm. And you don't have somebody who's really sponsoring you and really is backing you up. So another thing that would be fearful, and was for me too, was where are you going to get the clients from? You set up a law firm. You can run an overhead of $60,000 to $100,000 pretty quickly. And so where are you going to get, the business to run $1 million law firm? Now that's not necessarily a virtual model. That's more like bread, mortar and bricks. But the other thing now, I think there's the whole employment area and all of the obligations related to that, I think would scare people off. You have to be very careful as to running your law firm, and that could be something that could scare people away. So what is the impact of COVID? In this sense, I don't think COVID has had that much of an impact, and I'll tell you why. Because I was seeing people go virtual before, and virtual was a model before. Virtual now is, I think the change. So the fact that people were setting up virtual firms, that existed before COVID. Maybe not as big a trend as it will be now, but certainly was. I think now the real question is, to what degree will we see the practice of law stay the way it is now? And that is, like, for instance, I've done arbitrations, I've done motions, I've done pretrials, I've done examinations for discovery. I've done everything by Zoom. I didn't even, I thought Zoom was a feature on a camera before March of 2020. So the first question I have is, to what degree is that going to stay the way it is? Elizabeth Bennett Martin and Heather, my daughter, did a Court of Appeal hearing on Monday by Zoom. And my understanding is that in mid-November, they'll go back to full hearings at the courthouse. I hope that Zoom continue to be used for motions and other things like that. It's so much more efficient. I don't have to drive halfway across the country. I don't have to go downtown. I just walk to my office and I can do it there. And I think that's a great thing. The next big change is going to be to what degree do you have to have floor space? Like, for instance, if you're one of the large firms downtown and you're paying just an inordinate amount of money for those floors, can you get rid of 40 or 50% of your flooring space, but in hoteling arrangements where people can come in, but mostly they work from home? Our firm is definitely going to be, I don't think we're going to force anybody back into the firm again. If they like to come in, fine. If they don't, that's fine. I mean, in law, it's pretty easy to see the productivity of people, and that is, you look at their numbers. And And so I think that, like, I've got a boat, nice boat, it floats. I'm downtown during the summer. I spent 12 weeks on my boat this year. It was wonderful. It was great. The only thing was that when I got on the phone, I had to go down to the bedroom because my wife was in the main cabin and she was running her business out of there. But apart from that, most of my stuff was being done by email anyways. Whenever I had to do a discovery or something, I just hop the GO train, come out, walk to my office, and I do it there. I'd love to see that continue. I think that reduces the stress in the practice of law. It makes it much more humanizing in its own way. So I'd like to see that stay, but we'll see, to what degree will it snap back? I don't know. It'll never go back fully. And for me, I hope it doesn't go back a whole lot.
Now, you mentioned discoveries. Are there, like, do you prepare any differently with it being done
No.
over Zoom, or?
Exactly the same. I've done cross examinations and arbitrations. The only difference is if you are like, discoveries are funny things. It used to be you never wanted your client there, or people didn't take their client in. I've always taken my clients into every examination. I think it's really important they get to know it, and they have a right to be there. And if you've got your client sitting behind you or beside you, they can communicate with you very easily. It's much harder to do it when you're all on Zoom. So that's an issue. Apart from that, I don't see there's any differences. I really don't. I don't see myself as being effective in any form. So whether I'm in person or on Zoom, I don't think it much matters. I'll get the same result. That was a bit humorous.
No, and on that, so ironically enough, you mentioned international business law on the outset. So I'm actually teaching some global students international business law, and sort of the same joke that you had there before. And what is international business law? And we were learning about international arbitration and dispute resolutions and all that you're practicing in there. So I was wondering maybe if you can kind of give a little bit more insight in terms of when those disputes between countries and companies, and you add in the international perspective there. How has that been, and maybe you could tell us a bit about some of your experiences doing that, and whether virtually now or in person and stuff before, and how does that all work?
I haven't done well. Arbitrations I'm doing all the time, but they're domestic. And there really isn't that much difference between a domestic and an international arbitration. My comment is this: if you're going to be a litigator and you can get into arbitration, do it. Get into arbitration, do it. Get the arbitration clauses going, and you'll be it's a good way to handle disputes. They're more quick. They're quicker. You have to know your stuff earlier in the process. You really have to understand your case and understand what you want to do with it. I can take you through the various steps if you want me to, but the bottom line is that I far prefer arbitration to civil litigation. If you start an action in court today, you'll be lucky if you get the case heard in 3 to 5 years. You do it. If I start an arbitration today, it'll be done a year from now, and probably a lot more quicker. And I think the world of arbitration.
And in preparing, I guess, for arbitration versus litigation is in terms of your presentation there, in terms of bringing up evidence, is there sort of a different nuanced approach with that versus when you're at trial?
Sure, there is. The difference is this: when you start a piece of domestic litigation, what you do is you don't really need to know your case inside out and backwards. You need enough to put in a statement of defense, and you may not learn your case until you get to the discovery, and you may not even learn it then. You may not really learn it until you have to go to trial. And you don't really worry about structuring it in terms of what's going to happen when. It's it's in the rules. You'll get around to it. In arbitration, you have to understand your case thoroughly from the very beginning. On the very first phone call with the arbitrator, you're going to be setting up the schedule for the entire arbitration. You're going to have to answer questions as to what kind of production of documents you want, what kind of examination for discoveries do you want, if any. And you have to be ready to go with that. And you really have to understand what you want. You have to be ready to set it out. The next big difference is that it's much more writing intensive. You've got to do your opening memorial. You've got to do a responding memorial. You may have to do a rebuttal memorial. A memorial is just another word for your affidavits and all your exhibits and your written argument. Arbitrations are kind of neat because when you get into them, when you actually do the arbitration, you're given about 5 minutes to do an examination in chief, and all you're really doing is just warming up the witness, and then you submit your witness for cross-examination. And so you don't get into long examinations for chief. The case goes by more quickly, but then you have to write a closing memorial. You got to summarize all the evidence, and then you got to go through that whole process again. So it's really writing intensive. And but the biggest difference is from the moment you get an arbitration, you have to understand the arbitration as if you're ready to go to trial. And you have to have that in mind before the very first phone call. Because if you walk into that first phone call and you're not organized, you're going to get a procedure which is going to come back and bite you later.
And so I know you're not you're more focused here on domestic things there, but I remember I think the course was NAFTA. I can't remember exactly
No,
there, but the what is it, the chapter 11 sort of claims there with the investor state. So what's
you got chapter 11, the investor states, you got chapter 19, the countervailing duties and anti-dumping. And I was the softwood lumber dispute has gone on for years. It's gone on for 30, 40 years. I was I think I was the only Canadian counsel, I could be wrong on this, but I think I was the only Canadian counsel that appeared before the International Trade Commission on, or the panel, the binational panel in 2003 in the softwood lumber dispute. And I represented 9 First Nations from Northern Saskatchewan. And I was given more time to speak than Alberta, Manitoba, and Saskatchewan had. And I think I had like 10 minutes, 15 minutes max. And I was arguing on the basis of Aboriginal rights and Aboriginal title and all kinds of different things. And I remember starting off, I was in this room, I don't know, it's a Hilton, there it's hundreds of lawyers, it seemed. And I get up and I explained to the panel that, we're not Weyerhaeuser, which is one of the large lumber companies. And I remember that Weyerhaeuser is sitting right there. So I turned around and looked at them and said, no offense. They said none taken. And it was an amazing experience to do that. And I still think the Aboriginal interest had a point, because the argument was this: a countervailing duty is where a subsidy is provided. And it's required that the country that's going to put a duty on to the level of the subsidy has to prove what the subsidy is. Well, wait a minute. We're taking trees from land over which The Aboriginal people have rights. How can you say then what portion of those trees represents a subsidy and what represents their right? And if you can't do that, how can you countervail them? Well, that they rejected our our case, which is what I was told would happen by the people I was representing. They just wanted to be heard. They wanted to be they wanted their viewpoint stated in the international tribunal. And so there's that. But I shouldn't have been there because I should have been admitted to practice in the federal courts of the states in order to go there. So I had another lawyer there. And if anybody objected, I was going to step back and let them go up, but nobody objected. And I had my fun. And then we got the hell out of there and we went to see the Smithsonian Institute and a few other things, which was a lot of fun too, but that's a whole nother story. And chapter 11 complaints, chapter 11, I believe now has been eliminated. I don't think there is anymore, but that was, I was involved in a few of those. And one, in fact, went to a decision and went against us. And all it is, it's in terms of the arbitral process, it's the same. There's no difference between domestic and international arbitration as to the steps. The fascinating aspect there is, what's the basis for the claim? Has there been conduct tantamount to expropriation? And I was representing a bunch of guys who had tried to set up a garbage dump in Northern Ontario. And at the last minute, the government came along and slapped a bill on and took all the rights away from them after they'd been granted to them. And we lost on another issue. But that was intense. That was really intense. It was really personal. It was, it wasn't me who made it personal, but it was very involved, and it was fascinating. A fascinating 2 or 3 years of my life.
And in terms of, I guess, dispute resolution generally, there with the those organizations, or through NAFTA, or through international trade, there arbitration is generally the preferred method versus any type of litigation, right? I mean, how successful are those sort of dispute resolution mechanisms?
Okay, well, we're going to have to talk, if you want to talk that, we've got to break them down, because you've got you've got 3 different mechanisms in place. Chapter 18, I don't even know what the current ones are, so I'll give you the ones under the old NAFTA. Chapter 18 was a general dispute settlement mechanism, much like the World Trade Organization one. Chapter 19 was binational panels. And what happened there was that a last minute compromise in 1987 said that binational panels would be the route of appeal instead of taking the appeals domestically. So the International Trade Commission, and I can't remember, and the Department of Commerce would make their findings of subsidy and injury in their normal way, and then it would be appealed to the binational panels. And so the binational panels are really performing an appellate level. And what they would do is, if they won, if you won, it would be enforced through domestic law. The third one is the NAFTA Chapter 11, which is the arbitration. Obviously, arbitration is binding because you've got the ability to enforce. Chapter 19, if you've got a decision coming out and it's enforced through the domestic law, the appellate route, then that's enforcing, then that is binding. But if you talk about the general mechanism between either NAFTA's Chapter 18 or the World Trade Organization, you've got, is it enforceable? And the answer is, there's 2 answers to that. The first answer is no, it's not. Because the remedy is, you can't go to the court, or the NAFTA under Chapter 18 of the World Trade Organization can't go to the country and say, okay, now change your laws. You have to do it. This is binding on you. You have to do it by next week. What the remedy is that if you don't change it by X date, then there can be a duty placed upon your goods coming in. So let's assume you've breached an anti-dumping law and they value that at $100 million. You'll be able to put you'll be able to put duties on goods coming into that country up to $100 million. Okay, well, that's terrific, because all you've done now is you've driven up the cost inside your country for those goods. Secondly, what happens if you've got no trade between the two countries, which happened between Brazil and Canada in the Bombardier Embraer group of decisions? So, so you can say that that's not binding either, except, and this is the interesting thing, over time, you could see that even though it wasn't formally binding, they would be complied with generally. And so the World Trade Organization dispute settlement mechanism prior to Trump was I think as effective as any international organization could be. And this comes back to the whole weakness of international law.
Perfect. So Chuck, thank you so much for taking the time here, joining us and sharing all your insight. I was wondering if you have one last question here before you leave there, in terms, I know you given some advice there about students getting into the practice there, and certainly drawing on, your many courses over many years, as well as your own practice. Any final words of wisdom for students in law about what the future may hold for them, and anything you can share at all to wrap up? And thanks again for joining.
I got two things I'll say, and I said them to every class I've ever had. The first is that at some point when you're an articling student or a junior lawyer, we'll start with the articling student one. You're going to be given an assignment and you're going to blow it. It's going to be a disaster. You're not going to get it right. You're not going to figure it out. You're going to feel like you really missed the boat, that you're really stupid and everybody else could get it. And why did you ever choose the practice of law? So this is what I want you to remember. If it was important, they never would have given it to you. That's the first thing. The next thing is that at some point you're going to be in a courtroom. And it's going to be one of your first times in a courtroom, and the courtroom's going to be full of lawyers. And you've got a master or a judge who's going to come down on you like a ton of bricks, that you just feel like the dumbest person, that, how could you be so stupid? And look how embarrassed you are in front of all those people, and all of them are looking at you. And why did you ever choose law? And you know what they're all thinking? They're all thinking about the time it happened to them. Because we've all done it. We've all been there. And there's one final thing I'm going to say. The secret to a successful lawyer is the ability to stand back up, brush yourself off, and put one foot in front of the other. It doesn't matter. I can tell you that no matter what disasters you think you've had, I've had worse ones. And some of you just wonder how the hell you're ever going to survive them. But the bottom line is that it's the nature of law. Never give up. Always get up, brush yourself off, and move forward. And if you do that, you'll be a success.
Perfect. So thanks so much again, Chuck. There, all the best. Nice to reconnect with you after so many years.
Yeah.
Wish you again all the best with your practice. And thanks again for joining. And thanks for all the students for tuning in. And take care, everyone.
Okay. Bye now.